So today we are going to talk about legal purpose and object of a contract. That is essentially what the contract comprises of, what any contract comprises of. Normally, of course, we would certainly understand, just even without me telling you anything further about it, what does a contract comprise of? Contract certainly comprises of certain terms and certain conditions upon which, both the parties to a contract, they agree upon it and then they agree to execute the contract. So normally, what are the terms of the contract? Like we discussed during the last class, what can be the terms of the contract? Like it talks about consideration, what is that is something that is given in return for a value. Then what are the terms, a place of delivery, and so on. Last class we touched upon that aspect. Today we are going to delve into the aspect about the object of the contract, the legal purpose, and what are some of the um, what does a contract comprise of? Contract, just as an introduction for you, sometimes, okay, let me just admit of Diwali. Okay. So the contract normally comprises of terms and conditions, and also it comprises of certain warranties. Sometimes it has even guarantees. Just by way of an introduction, what is a condition? Again, what is a condition of a contract? It's nothing but essential or certain fundamental terms in a contract, certain conditions which must be complied with by the parties to the contract. Condition of contract, it can be, of course, expressed or implied, and that is what we learn throughout our contract law classes. It can be expressed or it can be implied. Contract conditions are normally binding in nature. So what are the elements, four key elements that we learned in the past? We spoke about offer, we spoke about acceptance, we spoke about consideration and the intention to create legal relations. Just as a flashback, what is the definition of a contract? An agreement that is enforceable in law is a contract. So what is an agreement? Offer plus acceptance is an agreement. So, what are the conditions of a valid contract? There must be a valid offer, there must be a valid acceptance, there must be consideration, and there must be an intention to create legal relations. So, the part of legal enforceability to an agreement, that is a thing that makes it a contract. That is an essential element that goes to make an agreement a contract. Contracts are enforceable in law. Agreements may or may not be enforceable law. That's why we say that all contracts are agreements, but not all agreements are contracts. So what are the conditions? So what is the difference basically between the conditions of a contract, the terms of contracts? For example, terms of a sale, you can say it is a kind of a broad arrangement between two parties outlining a contractual relationship and terms of sale. However, conditions are specific clauses that must be met before the deal or the contract gets through successfully or victoriously. So there are certain features of condition. The conditions can be expressed, condition can be, it's sometimes it can be implied. That is, even without it being expressed, it can be implied. So let us go through the slides now. It talks about legality of the object of the contract or legality of the purpose of the contract. Legality of the object of the contract or purpose of a contract is an important factor that gains prominence or comes to the fore, or that is something that has to be considered while validating a contract. The purpose of the contract must be legal and not illegal. Like, for example, a contract to sell drugs or murder is an illegal contract that goes without saying. And of course, it attracts criminal punishment. Here, in case either party is innocent, then it must be proved, if at all, if either party is innocent, then it must be proved in the court of law by appropriate evidence. So, therefore, the purpose and the object of the contract must be legal. It must be clearly defined in the scope clause of the contract. What are the different parts of the contract? There are different parts, of course, terms and conditions, warranties. And what we're going to learn about, an interesting concept here, we're going to learn about innominate terms that you can see here at point 3 on your screen. Innominate terms and also exclusion clauses. Let us see what the slide says. The different parts of the contract, of course, a contract may be made of the preamble, that is the prefatory statement or preliminary statement or an introduction statement, or it can be paragraphs or clauses, introductory clauses or preliminary statements or preamble, that's called the recitals, which is followed by the covenant provisions. Normally the preliminary statements or preamble talks about the name of the parties, the address of the parties, the type of the parties, that is whether they're company or they're individual, and certain licenses. Suppose if it's a company, then the you'll have to mention the company license. Suppose it's an individual, then the passport number. That is identification, basically identification details of the parties who are contracting. Apart from that, kind of a little general introduction is going to be there at the preamble, which is going to begin with, normally, with the word whereas. But these days contracts, then they, some of them, they do not use the term whereas, whereas people like me, we continue, I mean, I use that particular word whereas in my drafts. But today, like, um, I mean, people have done away with that word whereas, and they just directly mention as the intention of the parties, or basically they just say like the object of the contract or some other words that they may use. But normally, by and large, it begins with the word whereas, and then they say the parties have come together to, for example, to purchase certain goods or X number of goods for from so and so person and so on. So the preliminary statements basically talks about the introduction, which talks introduction, which has the name of the parties and also the purpose for which the contract has is being or formed, or for the purpose for which this particular document or contract is going to be signed, whatever purpose it is. So contract, broadly talking, it has preliminary statement, it has got its terms and conditions in the letter, in the covenant provisions, and then it has got representations, innominate terms, and also exclusion clauses. Terms may be express or it may be implied. Terms may take the form of a condition or a warranty. Implied terms may be deciphered under the law, general usage, customs, or practice, and by the court or judicial proceeding. Now, what is a condition? What is a condition? A condition constitutes a significant term in a contract, and the breach of which may attract repudiation or termination of a contract, and or the aggrieved party may sue for damages. So therefore, a condition of a contract is an essential or fundamental term in a contract. A condition of contract is a requirement where both the parties, or one of the party, or at least both the parties, must comply with. It may be express or implied. So that means the difference between a normal term and a condition is that conditions are specific clauses that must be met for the purpose of the purpose of the contract to be executed, or purpose of the contract to be met. So conditions have to be met. Are you understanding me? So, for example, what can be an example of a condition? Like sometimes payment terms can be a condition, or like payment terms of advance, 10% advance, 30% while in delivery, the balance 60% after delivery. Are you understanding me? So conditions can be it can be given as a whole, or it can be you know distributed throughout the contract. But conditions in a contract, it outlines the rules and expectations and the guidelines that is expected from the parties of the contract to be followed, and it must be followed so as to give effect to the contract. Now, what is a warranty? What is a warranty? A warranty is a covenant in a contract, as you can see on the screen, that when breached, the aggrieved party can call for rectification of the breach. When a covenant or when a warranty is breached, so the aggrieved party can call for rectification of the breach. Who is the aggrieved party? Who is at a receiving end, where when a particular warranty or a term of the contract is not complied with, it causes harm to the other party. So the party to whom the harm is caused is the aggrieved party. So the aggrieved party can call for rectification of the breach, or can sue for damages and not repudiate the contract. So here the contract basically cannot be terminated, but the remedy can be claimed in the form of rectifying the defect or suing for damages. So in the alternative return, the defective product, or they may return the defective product, or they may refuse to accept the product or services and rescind the contract and claim damages for lost time or lost business. So, therefore, warranty is a term of a contract, the breach of which entitles the innocent party to terminate the contract and claim damages or affirm the contract despite the breach and claim damages. In normal circumstances, the first option for a party is for the aggrieved party to claim from the innocent party. The first option is always to call for rectification of the breach, to call for making right that particular breach. Okay, or maybe even to sue for damages, but not necessarily repudiate or not necessarily terminate the contract. So, what is a test here? The test to understand whether a specific statement or a covenant in a contract is a condition or a warranty is whether the statement or the covenant hits the root of the contract or displaces the primary understanding between the parties. So, to substantiate further, we got a case here which explains in Pursuit versus Spears. The court held that a condition is a major term of the contract which goes to the root of the contract. And if the condition is breached, the innocent party is entitled to end or repudiate the contract and claim damages. Now, in Bettany versus Guy, the court held that warranties are minor terms of a contract which are not central. They are not central to the existence of the contract. If a warranty is breached, the innocent party may claim damages but cannot end the contract. Now, in this case, Bettany agreed by contract to perform as an opera singer for a period of 3 months. The singer got ill and neglected 6 days of rehearsals. The employer dismissed the singer, terminated the contract, and replaced the singer with an alternate opera singer. Under the facts and circumstances of this case, the court was of the opinion that Bettany was in breach of warranty and held that the employer was not entitled to terminate the contract. So, missing the rehearsals did not hit the root of the contract. Next is innominate terms. Now, what is innominate term? Innominate term is something which is neither a condition or neither a guarantee. It is something that comes in between, innominate terms. So there may be certain terms in a contract that cannot be clearly categorized as a condition or a warranty and may have the hue or the color of both, which such terms are referred to as innominate terms. You could also call it as intermediate terms. So terms of the contract that cannot be really classified as a condition or a warranty are called intermediate terms or innominate terms. What is an example? Just to give you an example, if you buy a car, a warranty might be that it will be free from defects for a certain period of time. Now, if a car develops a defect within that period, you can claim damages, but you cannot terminate the contract. Now, an innominate term or an intermediate term is a term of a contract that's neither condition nor a warranty. So, how would you identify? Now, this innominate term approach here, the court will assess the impact of the breach of such term to identify how it should be properly characterized. Now, here, this approach was basically the innominate term approach was established in the case of Hong Kong fur shipping case. The court substantiated in the case that rather than classifying the terms as terms or conditions, terms as conditions or warranties must look to the effect of breach. In case a breach of an innominate term has a material impact, then the remedy to be applied is like that of breach of condition. In case a breach of innominate term has an immaterial impact, then the remedy to be applied is like that of the breach of warranty. And let's go to the details of this case. Hong Kong fur shipping versus Kawasaki Kaizen Kaisha, which is a landmark case decided by Queen's Bench way back in 1962, an English contract law case, which introduced the concept of innominate terms as a category between warranties and conditions. That is, more so, you could call it also as an intermediate term. So in this case, D chartered his ship. One Mr. D, he chartered his ship to P and was contracted to ensure that the vessel was seaworthy and in every way fitted for ordinary cargo service. D failed to provide competent personnel to maintain the ship so that it was only at sea for 8.5 weeks of the first 7 months of the charter. The court held that the contract would not be terminated since, given the time remaining on the charter and D's efforts to repair the ship, P had not been substantially deprived of the whole benefit of the contract. So the term maintenance here was held to be neither a condition nor a warranty and was an innominate term that would only terminate the contract if its breach had such consequences serious enough to amount to the frustration of the commercial purpose of the venture. And there was Justice Upjohn, where he said the parties can specify in a contract which terms or conditions and which stipulations. He says seaworthiness cannot be a condition because the slightest thing can lead to its breach. Example, failing to hammer in a nail. And it cannot have been intended that the contract should be terminated if any of these common trivial things should happen. What are the exclusion clauses? Such a clause in a contract limits or excludes altogether the liability of one or more parties under a contract. For enforcing the exclusion clause, the question is whether it is part of the contract or not. So, this can be ascertained or determined by examining if such a clause finds its place in a signed contract or if such an exclusion has been brought to the attention of the other party in the absence of a signed contract. So, exclusion clauses will only apply to intra-virus the terms or scope of the contract, that is within the terms or scope of the contract. There's a case of Olive versus Marlborough Court Limited. Here, the claimant's fur coat was stolen from the hotel room after the claimant checked into the hotel. So, there was someone who stole the fur coat of of the claimant, that is a lady who checked into the hotel room and her fur coat went missing. So, well, the dealing or the check-in formalities were made at the reception desk as usual, where there was no mention of an exclusion clause. In the hotel room, on the back of the door, a notice sought to exclude liability of the hotel for any lost, stolen, or damaged property. So there was a notice at the back of the door saying that the hotel is not responsible for any lost, stolen, or damaged property. So now the lady whose fur coat was stolen, she was flabbergasted. She was shocked. She was confused. And then she said, now what's going to happen? So she filed a case against the hotel. The hotel's defense was, we already have an exclusion clause, which is exhibited, or there's a kind of a paper or whatever which is stuck at the back of the door of the hotel room that she occupied, saying that we do not take any responsibility for any lost, stolen, or damaged property. So here the court held that the notice was ineffective. The contract had already been made by the time the claimant had seen the notice, because she did not see the notice earlier. The contract was actually made at the time where she was doing a check-in and formalities at the reception desk. So the contract had already been made by the time the claimant had seen the notice. Therefore, the notice behind the door did not form part of the contract. Next is the history of dealings. So court will conclude or infer the knowledge of the parties based on previous dealings. For example, in this case, in Bellman New Ferry Company Limited versus Robertson. In this case, a ferry company used a private wharf in their business of running a steam ferry from Sydney to Balmain. On the wharf were two turnstiles. Passengers entering or exiting the wharf had to comply with the notice affixed at the gate and were required to pay 1 penny to the officer at the turnstile or to the baffle gates. One passenger named Robertson. What is a turnstile? What's a turnstile? A kind of an entrance or an exit where there is a kind of a gate or kind of what do you say, some metal rolling system which can prohibit one's entry or exit. That's a turnstile door. So there they said that passengers entering or exiting the wharf had to comply with the notice that is affixed at the gate and were required to pay 1 penny to the officer at the turnstiles or the baffle gates. So one passenger named Robinson, he paid the fare and stepped onto the wharf, but missed the ferry he wanted to catch. Robinson sought to leave the wharf and during exit was asked to pay another penny. At this, Robinson was annoyed and he refused point blank. This led to litigation. The court held Robinson was bound by the terms of the contract as exhibited on the notice board. The court concluded that having regularly traveled on the company's ferry, Robinson had knowledge of the terms upon which the ferry company conducted its business. Thereby, he was made liable. Why? Because they went into the history of dealings that he was a common passenger on that route. So that means he already knows the rules and regulations of that area and the procedure of using the wharf and even catching the ferry and so on. Next is a contra proferentum rule. Now, this is a rule of interpretation used by the courts in case of ambiguities in exclusion clauses and is interpreted strictly and against the party relying on it. So the rule only applies when the clause is ambiguous in nature. This is a contra proferentum rule. Next, we'll talk about contingent contracts. So contingent contracts are contracts, the execution of which depends on upon happening of a particular event. So the simple meaning of contingent is that subject to a chance. So Section 31 of the Indian Contract Act refers to a contingent contract as if two or more parties enter into a contract to do or not to do something, if an event which is collateral to the contract does or does not happen. So that is contingent contract. For example, insurance contracts, indemnity contracts. So contingent contracts are valid contracts, but they are different or distinct from wagering contracts. Not all wagering contracts are not legal, but contingent contracts, the best example for you would be insurance contract, where the contract would really be triggered. The contract would be triggered and the party contracting would be expected to do something when a particular event happens. So therefore, contingent contracts are not enforceable if the event or the condition does not occur or happen. For example, it depends on the happening or non-occurrence of an event. So there is a condition attached. It must be a future event. Next is the event specified as a condition must be collateral to the contract. Or next is it it is a valid contract and the performance under the contract must be conditional. However, the parties may perform generally the outlined duties. The contingent conditions must be a possible event and not an impossible one. Now, in case of Frost versus Knight, the defendant promised to marry the plaintiff after the death of her father. While the father was still alive, he married another woman, and thus it was held that there was no opportunity or chance left that the defendant would now marry the plaintiff. Thus, the plaintiff had the right to sue him. So, thereby, we have gone through different kind of concepts that go on, or terms that go on to form a part of the contract. We spoke about condition, terms, innominate terms, warranty, contra proferentum, and so on. Talking about contra proferentum again, it's also known as interpretation against the draftman. That is, it's a simple doctrine of contractual interpretation where it provides that where a promise or an agreement or a term is ambiguous or it's unclear, the most preferred meaning should be the one that works against the interest of the party who provided the wording. So that is contra, that is against proferentum rule. That is a rule of interpretation or rule of contractual interpretation that states an ambiguous or an unclear contract term should be construed against the drafter of the contract. So next we're going to talk about termination of contract.